We just had a chance to listen to Whitney Harris, one of the really foremost protagonists on behalf of the world of international law, who was there at Nuremberg and who continues to speak today. But he was also speaking to these folks on the stage now. These are the current prosecutors on the world stage, and it's just such a thrill to welcome all of you. And there'll be a formal introduction in just 1 second. This session, called The Past and the Present, is entitled The 20th Century, Atrocity, the Rule of Law, and the Laws of Armed Conflict in an Age of Extremes. Are the laws of armed conflict relevant today? This is a moderated session, and it'll be moderated by two individuals. The first, who sort of introduced herself, but let me give a little formal introduction, Laila Sadat, Professor Laila Sadat, at the Washington University School of Law, and also currently the director of the Whitney R. Harris Institute for Global Legal Studies. She has a long resume, and for the sake of time, since we probably want to get into everything, but I do want to note one of the things that Laila was the first, and to date, really the only female to write an extensive book on the rule of international law. So to Laila Sadat, thank you very much. The other moderator who will be standing behind the podium is David Schiffer. We're thrilled that David was able to arrive. He had quite an odyssey yesterday from Chicago. Probably been easier for us to send a driver for you, David. David is the endowed professor of law and the director of the Center for International Human Rights at Northwestern University School of Law. But for today's purposes, it's also worthy to note that David was the U.S. Ambassador at Large for war crimes issues, 1997 to 2001 under President Clinton, and led the United States delegation in the UN talks establishing the International Criminal Court. David was right there on behalf of the United States when the discussions went on, which ultimately resulted in the Rome Treaty. Without any further ado, our moderator for this session, Professor David Schiffer.
Thanks very much, Gregory. I'm going to take the opportunity to stand, because then when we open the discussion for questions from the audience, I think it gives me a much easier way of ascertaining who would like to ask a question. So Laila is also a co-moderator, and she's going to jump in at will along with myself as we guide this discussion. You have in front of you perhaps the most distinguished gathering of international prosecutors and Nuremberg prosecutors that we've ever brought together all at one time. There may be an exception to that rule, but I think this is an extraordinary opportunity for this audience, and I hope it's a enjoyable and interesting opportunity for our distinguished prosecutors as well. All of these individuals are in fact making history in real time, and if each one of these prosecutors could have a John Barrett in their future, I think they will be extremely well served. So that 50 years from now, there will be John Barrett Juniors who will be explaining to us what each of these prosecutors has achieved with such remarkable clarity and significance in their work in the cause of international criminal justice. I want to introduce them to you very briefly. I'm not going through bios here, but I want everyone to know who's basically sitting with us today. I'm going to start at the far end. Next to Laila Sadat is Robert Pettit, who is the international co-prosecutor of the extraordinary chambers in the courts of Cambodia, where the surviving leaders of the Khmer Rouge during the Pol Pot regime and others who are most responsible for the atrocities during the Pol Pot regime are subject to investigation. That court is now up and running, and we are extremely honored that Mr. Pettit has flown in all the way from Cambodia for this event to be with you this morning, and we honor that. Sir Desmond de Silva was the prosecutor until relatively recently of the Special Court for Sierra Leone, flies in from London, where he's a very, very distinguished barrister. I saw him in action in Freetown, and it was a court extremely well served by Mr. Sevilla's work there. We have Hassan Jallo, who is the prosecutor of the International Criminal Tribunal for Rwanda, where the genocide of 1994 is being investigated and prosecuted, and he is flown in from Arusha, Tanzania. We have next to him David Tolbert, who is an American. He's the deputy prosecutor of the International Criminal Tribunal for the former Yugoslavia in The Hague. His boss is Carla Del Ponte, who was not able to join us today, but we are extremely well served by someone who has been there really almost from the beginning in the early 1990s with the tribunal, and that is David Tolbert. He knows and is performing an extraordinary job at the Yugoslav Tribunal in The Hague. Next to him, welcome. Next to him is Stephen Rapp, who is now the prosecutor of the Special Court for Sierra Leone, and he is the prosecutor of Charles Taylor, where the trial is being held in The Hague for security reasons. And so we're very honored to have Mr. Rapp with us today. Next to him is David Crane, who's now a Professor David Crane, but was the first prosecutor for 3 years of the Special Court for Sierra Leone, and he was the one who drafted and then achieved approval from the judges of the indictment against Charles Taylor, as well as all those other indictments which have been prosecuted and trials have now been held. Certain trial chamber judgments have been rendered. So all of that spade work was done on David Crane's watch. And finally, we have Luis MorenoOcampo, who is the prosecutor of the Permanent International Criminal Court. Hails from Argentina and has been there from the beginning, the first and still the prosecutor of the International Criminal Court. And you will not only hear much about what he has done so far, but the future is all his now before the Permanent Court. And you're going to be hearing a lot about prosecutions pertaining to Darfur, the Congo, Uganda, Central African Republic, and who knows what's next. I'd like to start this out with a somewhat cosmic question for our prosecutors before we get into some of the more exciting, detailed questions about the work of their tribunals and some of the leading issues of our times with respect to international criminal law. I noted that in Whitney Harris's book, Tyranny on Trial, which you can grab a copy of outside, there is a very interesting passage about one of the reasons why we're here today, which is to celebrate the 100th anniversary of the Hague Rules of 1907, which Professor Barrett so brilliantly described to us. In that book, on page 505, Whitney, there's an interesting passage which states, the Nuremberg Tribunal concluded that by 1939, the rules set out in the Hague Convention of 1907 were recognized by all civilized nations and were regarded as being declaratory of the laws and customs of war. Nor was this an innovation. And then he goes on to cite an early 1945 German High Command ruling or decision among the very highest German officials that, hey, they still have to comply with Hague. He goes on to write, the tribunal applied this reasoning, i.e. the Germans' own reasoning of themselves, and it held the defendants responsible for complying with the standards of humane warfare as they had evolved in judicial decisions, in international conventions, and in the common experience of military men and the common judgment of mankind. notwithstanding the non-adherence by the Soviet Union to those basic conventions. Now, I'm going to ask this question based upon a provision in the Hague Rules, which is at the very beginning, in the preamble of the Hague Rules, is a very, very significant passage that we call, among us international lawyers, the Martens Clause. And the Martens Clause reads as follows, and then I'll stop talking. Until a more complete code of the laws of war has been issued, the high contracting parties deem it expedient to declare that, in cases not included in the regulations adopted by them, the inhabitants and the belligerents remain under the protection and the rule of the principles of the law of nations as they result from the usages established among civilized peoples, from the laws of humanity, and the dictates of the public conscience, which is just a great clause. So what I would like to ask the prosecutors here, and I'll start off by asking a particular one after I ask the question, then we'll get the ball rolling, is first, how often in your work have you found it useful to invoke the Hague Rules of 1907? And how often does that Martens Clause influence, perhaps even inspire your work? In other words, that you look not only to the codified rules of law, but you are very dependent upon what we call customary law, the law that is the public conscience of humankind. And I just want to ask that very, very broad question to start this discussion. To what extent do you lift yourself above all of the codified provisions that are part of the mandates of your statutes to have that same inspiration that our prosecutors, Whitney Harris and Henry King, had at Nuremberg, and how they looked back at the Hague Rules of 1907? And if I could start that by asking David Tolbert of the Yugoslav Tribunal, where I think more than any other tribunal, war crimes are prosecuted before the Yugoslav Tribunal, whereas other tribunals focus on crimes against humanity and genocide to a very large extent. David, would you like to elucidate on that particular point?
Yes, and very good question to start out with. I do want to say one thing. Layla said she was the only female representing females here. I am representing a female too, Carol Del Ponte. I don't think anybody would ever confuse us. And a second female that I think deserves to be mentioned here is Louise Arbour, who was the second prosecutor at the ICTY and the ICTR. So I think they both would like to be here today, and they're just a lot busier than the rest of us. So in response to your question, David, yes, the 1907 rules are a very important part and a critical element of the law that we apply in case after case in the Yugoslav Tribunal. And I think it's interesting to look back and think back to 1993 when the tribunal was established, because I think that's where your question really points to. And yes, in 1993, we faced the situation, and we had the 1907 rules, we had the Geneva Conventions of 1949, the Genocide Convention, etc. But post-Nuremberg, there's very little development of that law. So over the last 10 years at the ICTY, the ICTR, and then the other tribunals you're looking at up here today, the law has developed a great deal. So I would say that whereas in 1993 and 94, in the early days, we were looking very much to inspiration from the Martens Clause and from customary law, those rules have developed significantly over the past 10 or 15 years. Yes, of course, the court is referring to customary law in its decisions, but that law is now much, much clearer. And one of the great legacies of the ICTY and the ICTR and now the other courts that you see is that whereas there really was no case law that developed these concepts, they were laws on paper, these now are living, breathing laws, and they've been applied in time after time. And there are some major decisions out there, like rape is a crime against humanity, rape is a war crime, that our courts have developed and really laid the basis for the International Criminal Court. Now, we drew on the inspiration of Nuremberg and the precedents of Nuremberg, but there was a huge gap there and a great deal of developments between that. So yes, 1907 rules are very important. Yes, the Martens Clause inspiration was very important. But today we sit in a very different place than we did 10 or 15 years ago. We sit in a different place in terms of the definition of the law, and something that I think is worth mentioning, not directly to your question, but you see these individuals sitting around the table today. You also, back in The Hague, we have lawyers who are now international criminal lawyers. In The Hague, in Arusha, and all of these in Cambodia, and all of these places where 10 or 15 years ago, that really didn't exist. We had the Nuremberg, our pioneers of Nuremberg, but we didn't have a profession of international criminal lawyers. This is a revolutionary change, both in our profession and the way these things are viewed, and the Martens Clause and these inspirations which continue, these ideals that continue to guide us are important. But now there's a lot more substance to the ship than there was in 1993.
Stephen
Yeah,
Rapp?
just want to note, I mean, I've worked at the Rwanda Tribunal for 5.5 years and now at the Sierra Leone Special Court. Our focus hasn't been so much the law of armed conflict, the law of The Hague, as it has been the law of Geneva. Mm-hmm. But nonetheless, the concept that underlies the Martens Clause, the reliance on international humanitarian law, the law of civilized people, has been critical in both courts because of the importance of our prosecutions for crimes against humanity and war crimes. And we've had to draw from international customary law to get there. Our statutes were adopted after the crime, but were based upon the existence of crime in customary international law, unlike Luis's situation where there's a treaty-based statute. And so when the framers of our statute said that you could prosecute potentially as another violation of international humanitarian law the recruitment or use and hostilities of children under the age of 15, that was an effort to state that that was international humanitarian law at the time that those offenses occurred in the 1990s. It was nonetheless necessary for our judges to look at that, the motions to dismiss, preliminary motions that went to our appeals chamber, and they had to find that as a matter of customary international laws, that was a crime when those young people were recruited. And in the last few weeks, we've had the first convictions really in the history of the world for that crime, based upon international custom. Same thing is happening. David filed a prosecution for the crime of forced marriage as another inhuman act, as a crime against humanity. Never defined before, but the principle that inhuman acts that are of an equal gravity to recognized crimes against humanity can be prosecuted at the international level. We recently had a judgment where one judge was prepared to convict and two acquitted, but that, as we can do at the international level, prosecutors can appeal, and we have that issue on appeal now before our appeals chamber. But that'll depend on their analysis of customary international law, and we'll be citing the Martens Clause and the principles that underlie it.
I think it's a bright red thread. I'm sorry, did I jump
No,
in?
no, go ahead.
No, go ahead.
Go ahead, David. Yeah.
I think it's a bright red thread that really from the Martens Clause dealing with humanity and conflict, you see the Geneva Conventions picking it up in various common articles, which stem into just the bedrock principle of Common Article 3 in internal armed conflict, from which many of us began our prosecutions. So really, in some ways, the Hague Rules, the Martens Clause and the Hague Rules, really it's the center point of a broader development of both customary as well as statutory law. Excuse me, Rebecca.
No,
Robert
I was just
Pettit?
gonna say, if you want to, how relevant the Hague Convention still is. I mean, we're the latest tribunal, but in a sense we're the oldest, because we're going to have to reach back to 1975 to 79 to determine what the law was then, and we're not going to have the benefit of to a certain extent, the jurisprudence that's been developed in the last 15 years. So we're going to have to look back at the Nuremberg legacy probably much more closely than the other tribunals in a sense, and anything forward. So it's certainly relevant to us and to our work. And thinking about the Martens Clause, I mean,
if you read it a couple of times, it basically defines, I guess, why most of us do this sort of thing.
Absolutely.
It speaks to what I guess, I assume, is each of us, our motivation to do this, to uphold these principles that we believe everybody should be ruled by and live by. So I don't see it ever become, well, I hope, irrelevant.
If I might just add this, David, to
Desmond De Silva.
as far as Martin's clause is concerned, David Crane has very vividly described it as the bright red thread. I'd call it the golden thread, because its inspirational guidance is huge. But coming back to the issue that was raised as to its real relevance today, it's right to say, and I agree with David Tolbert, of course, that there is now this huge body and growing body of jurisprudence which signposts the way to the future. And to an extent, the past is a vital guide and inspiration to us. But what we do today in the creation of jurisprudence in these international criminal courts, day after day, judgment after judgment, they will be our true signposts for the future. And of course, they have drawn their strength and sustenance from clauses such as the Martin's Clause. And therefore we see this great body of international jurisprudence now rolling forward, hopefully to usher in a more peaceful world, or at least, if not a more peaceful world, a world in which those who contravene and violate these fundamental laws of man are brought to account.
Let me, if I may, Hassan Jallo.
Well, at the Rwanda tribunal, of course, we have the same jurisdiction in terms of offenses, crimes with the ICTY. We deal with genocide, with war crimes, and crimes against humanity. But in practice, our work has concentrated more on issues of genocide and war crimes, crimes against humanity, not so much war crimes. We've had a couple of judgments dealing with that. But nonetheless, the spirit, I think, behind the Martin's Clause of penalizing what may not amount to decent and fair behavior, all the same is something that influences the work of the tribunal in relation to crimes against humanity and war crime and genocide, because the categories of inhumane acts, for instance, is something that is quite open, and I believe in interpretation, in judicial interpretation of what are inhumane acts which constitute, crimes against humanity, for instance, the judges are guided by the spirit which is behind the Martin's Clause itself. And so you've had situations where, for instance, in relation to genocide and crimes against humanity, sexual violence, crimes of rape have all been fitted by the judges as falling within those two offenses. Even though it's quite possible that at the time those statutes were drafted, sexual violence may not have been in contemplation of the drafters themselves. But the judges have been able to interpret those two crimes in order to be able to include crimes of sexual violence, rape, etc., as constituting, crimes against humanity and also genocide as well.
Let me ask Leila to jump in with a question.
Yeah, well, one of the things, can you hear me? One of the things that, sorry.
Now we can.
One of the things that I think the Martin's Clause also opened up was something perhaps not anticipated by the 1907 Hague Convention, was the extent to which internal, non-international armed conflict would be the conflict of the second half of the 20th century. The Geneva Conventions open a small window to that in what we call Common Article 3, and I thought maybe the prosecutors would like to talk a little bit about how they've developed in an extraordinary way the rules relating to internal armed conflict. And of course, in the International Criminal Court negotiations, that was a huge issue, and I think Luis will have an extraordinary job with that. But I thought maybe we could speak to that development.
Absolutely. In fact, why
Maybe
don't we
start with Hassan.
Yeah, Hassan, Common Article 3 began with your very first, well, you were still in Sierra Leone, but
Right.
the Akayesu case.
Right, with the Akiyesu and with
Yes,
Rwanda
I mean,
tribunal?
for Rwanda, as I said, the bulk of our work has been on the genocide and crimes against humanity. Nonetheless, it was a situation of an armed conflict in Rwanda, which was going on parallel with the genocide. You had the government forces fighting with the rebel RPF forces. And of course, the laws, the Geneva Conventions and the laws of war have been held to be applicable to that particular situation. And so we've had a couple of people convicted of violations of the laws of war, alongside with people who have been convicted of genocide and crimes against humanity. We're still doing a lot more investigations into allegations of war crimes which may have been committed by the rebel side as opposed to the government side. But we haven't come to any conclusion on those inquiries as yet.
Let me ask Louis MorenoOcampo, the prosecutor of the International Criminal Court, to what extent, Louis, do you find Common Article 3, which is the internal conflict provision of the Geneva Conventions of 1949 that Leila was speaking about, and which, frankly, we've heard a lot about recently in the United States in terms of our own situation with dealing with the Geneva Conventions. But Louise, to what extent does Common Article 3, to what extent is that a part of your daily work and your preparation of indictments at the ICC?
Some way they are building blocks, no? What they did in Nuremberg was the beginning and was a landmark, but was not yet the law, was the first case. And then you have the conventions and the tribunals. So, as David said, now, since 1993, was a new situation. But the issue for me, and that's why I would be a little fighting with you on this issue of being inventive. In 1998, it was a revolution. And David Sheffer will tell about this because I was not there, he was there. So David will talk about Rome. But Rome was a revolution because Rome is now the law. It's law in two senses. First, it's a treaty in which people discuss and 120 states approve, and today 105 states ratify. So it's no more customary law, it's the law. And the other issue was totally revolutionary, is it's the permanent court applying the law. Because what's happened is, what people learn is, okay, the law is very important, but law with no enforcement is not so effective. And this is a second revolution, and my job is to put this revolution in place. So I had to be absolutely legalistic. So I have a law, clear, and I remember when I was appointed, I met with the ambassador from Europe, and they were telling me, prosecutor, you are from Argentina, a civil law country, but you work a lot in US. Are you a civil law or a common law lawyer? So this also. And then for me it was easy because I took the status and said, look, I'm a lawyer, this is my law. Where it's coming, I don't care. This is the law. Because that's the question. So for me, what I'm trying to present to you is, we are discussing different steps of evolution, but now is the law. And my second point, so for me, the law is the Rome Treaty, what you discuss. And it's interesting because David is one of David did not sign, but I would believe 80% or 90%, how a big part of the Rome Treaty is basically you promote ideas. So US had the biggest delegation, so even US, who is not member of the Rome Treaty, had no problem with the law. They had a problem with the prosecutor, but it's different. No, and that's what I will go on this. So for me, I am presenting a different view. It's not just what's happened in 1997, because it was very important Nuremberg. It's critically important Yugoslavia and Rwanda and Sierra Leone. All this is evolution, but now we are in a different moment in which it's the law. And then for me, the problem is not just the law for prosecutors and judges. It's the law for you, citizens of the world. Witness is advocating vehemently in a great style about the idea to transform aggression in a really crime under the treaty. But I cannot talk about this because I'm a prosecutor. But you, citizens of the world, can do it. Because in 2009 will be a discussion between the states about this issue. And that's the big issue probably in terms of define the law. Aggression will become a crime? How will be enforced? That's the issue for you. I'm just a prosecutor. You are the citizen. So the law is not just for prosecutors and judges. The law is for citizens. And this is something we have to learn. And I will finish with this because maybe I can, no, because I like to talk to them, because in US, you have a strong tradition to call your congressman and say, hey, it happened this, and they listen to you. But now, what I see, for instance, in Darfur, I'm dealing with Darfur, and US has a strong commitment to do something in Darfur. But then you request your president, who is important, but is one of the 15 members of the Security Council, and he cannot define what's happening inside Sudan. So now we have new institutions, and we have to learn how to deal with new institutions, with the spirit of the Hague, but in this new framework. And that, for me, is the new challenge, and maybe we can talk after about this.
Excellent. Stephen?
Yeah, just back to the Common Article 3 of business.
Yeah, they would.
To deal with that for just a moment, because it's vital to us in Sierra Leone.
Yes, indeed.
Particularly as supplemented by the additional Protocol 2, which is ratified by Sierra Leone and is part of customary international law, albeit not ratified by the United States, because what we had there was a conflict and particular individuals leading forces that were engaged in terrorism and collective punishment, mass murders of individuals on a wholesale basis, mutilations, enslavement, but basically to terrorize a whole population into submission or to punish those that weren't viewed as allied. And that law comes to us from Common Article 3, which was then written into our statute, with the additions from additional Protocol 2 that had earlier been written into the statute of the ICTR. And without that, we really couldn't define the crime against Charles Taylor. Intriguingly, we have the crime of terrorism via the additional Protocol 2 and the law of Common Article 3. I don't think that's in the ICTR statute or the ICC statute for reasons of controversy, but nonetheless, it's part of international customary law.
David, I think Henry had an intervention.
Yes, Henry King.
I had a question. At Nuremberg, I usually use the Hague Convention in writing my briefs. We talk about customary international law. Now, what I'm concerned about is the proof of customary international law and the limits. Are there limits in terms of protecting the defendants? My personal experience has been with statutes, and that's what I leaned on, and was quite successful in that. But now, this is a new dimension, or it's a dimension that was in the statute at Nuremberg, but I'd like to see its limits. Perhaps you can comment on some of the proof of customary international law and the limits.
If I could, just so everyone knows, you may not have heard it in the back, Henry King was asking, because of the influence of the Hague Rules, which were regarded as customary international law by the time of Nuremberg, and he had to work within that context, to what extent now in the 1990s and in the early part of the 21st century do they still rely upon that principle of customary international law, but also what are the limits to it? Where does it stop and constrain the prosecutor? And I know David Tolbert has a lot of experience on this. Perhaps I could ask David to answer that.
Well, I guess the short answer is it stops with the judges, because at the end of the day, judges have the responsibility to determine what customary international law is. David, I wonder if some of our audience is even struggling with the idea of what you might just take a second or two to otherwise we get way ahead of the audience.
And I felt a little that way as we're talking about what we call Common Article 3. Let me just say that at the Yugoslav Tribunal, Common Article 3 has been interpreted by the judges of the tribunal to frankly represent general principles of international humanitarian law that would apply not only to internal conflicts, which was the original focus of the Geneva Conventions with that article, the rest of it all being international conflicts, but frankly, these principles now are deeply embedded in the law of international armed conflicts. So they become a bedrock, and it's why it's so important when the United States deals with this issue. We just had an executive order come out last month, or earlier this month, whenever, last month I think, trying to interpret from the US perspective Common Article 3 and what it really means, and it has led to a tremendous controversy among us lawyers to try to go in that direction in the way that the administration did. But in any event, let me just remind the audience that these are principles in Common Article 3, such as prohibiting the following acts under any circumstances whatsoever, period. Violence to life and person, in particular murder of all kinds, mutilation, cruel treatment, and torture, taking of hostages, outrages upon personal dignity, in particular humiliating and degrading treatment, the passing of sentences and the carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees which are recognized as indispensable by civilized peoples. And it's that last provision, you gotta have a pretty good court in place, that was the center of some of the judgment in the Hamdan case before the Supreme Court, where the Supreme Court said to the administration, you forgot about that. You got to go back to the drawing board in Guantanamo, reconstitute your courts, and comply with that provision of Common Article 3. And it doesn't matter if it's internal or external, comply with it. So that's some of the importance. Customary international law, of course, is not only the combination of everything that's codified in law, but also that practice of nations whereby through adherence and general recognition and respect for certain principles of law, whether they're codified or not, we reach a point in law where we regard it as customary international law and courts begin to apply it as such and enforce it as law. May I?
If I could come back to,
yeah,
to
David.
my answer, and at the end of the day, of course, I'm from the prosecution side, but I think what we hear a lot more from the defense is not the question of customary international law, but more the modes of liability by which these accused are held responsible. So at the Yugoslav Tribunal, we now have a large body of law on joint criminal enterprise. Now, joint criminal enterprise actually wasn't referenced in the statute itself. It was, of course, it existed in some of the case law in Nuremberg, and the Tadic case early on indicated that joint criminal enterprise would be an appropriate mode of liability. We have really relied on that, and what the defense, I think, has pushed back on is less what customary international law is. There's been less disagreement about that, although, of course, in certain instances there have been, but more on the modes of liability in joint criminal enterprise. So if you had 8 or 9 defense counsel up here, as opposed to 8 or 9 prosecutors, what you would probably hear, at least if they were my tribunal or our tribunal, we would hear a lot about joint criminal enterprise, the misuse of joint criminal enterprise, the overextension of joint criminal enterprise, and modes of liability, probably a lot more than customary international law and the limits thereof, because I think the judges have held that in check. They haven't pushed the boundaries too much.
I want to, let me get to Desmond and then Stephen, and then I want to move to a sort of a new issue that extends beyond law into politics. Yes, Desmond.
Thank you very much. Well, I think that in talking to an audience such as yourselves, it's very important to take you through the sort of problems we have as international prosecutors. Now, one of the problems that David Crane and I had in Sierra Leone was one of the curses of modern warfare, and that is the use of children in warfare. That is a monstrous curse, because we found a situation in Sierra Leone where rebel forces would get children to murder their own parents first. And of course, once you kill your parents, all taboos are gone. You can then be controlled and called upon to do whatever evil your masters call upon you to perform. And nobody up to recently had dealt with the issue as to whether or not the use of child soldiers was a crime in international law. Now, I personally had to argue, and I remember David was in court, that this whole issue as to whether or not the use of child soldiers was now a violation of customary international law, and so on. And indeed, we succeeded. And for the first time in history, an international criminal tribunal determined that the use of child soldiers, the recruitment and use of child soldiers in warfare It's now an international crime. I think since 1998, I think, they held. So this is customary international law in operation, you see, where it coalesces into something that there comes a point when a court feels right. We're able to say affirmatively, this is now, and henceforth will be, considered to be a crime at international criminal law. And this is vital. You see, this is how customary international law develops, and this is perhaps a very good example of it. And we are extremely proud of all the things we've done in Sierra Leone. Perhaps my proudest moment was to have that judgment that might protect children in the future, that might make warlords ponder twice about the use of children in warfare, because the word has gone out. It is now the law that were they to do so, they commit a crime at international law.
Just as an aside,
Okay, an aside, and then Hassan.
well, just as an
And
aside,
Stephen,
it was Stephen Rapp's team who secured the convictions on child soldiers this summer. So that not only have we had an appellate court saying that the unlawful recruitment of children into an armed conflict crystallized into customary international law as of 1994, I think it was, but we also now have, after we charge them, we now have a conviction of majority of the indictees of recruitment of child soldiers. So it's now it's a cornerstone that cynical warlords and leaders of countries who recruit children are going to pay the price for that, and that is all evolved through custom.
And Stephen?
Yeah, I just want, because the question was about limits and the things that we should be concerned about in this area. And I want to be clear that there are statutes. I mean, the Geneva Convention, the Common Article 3, is a statute. Everybody in the world has adopted that. There are other things that haven't been adopted, like the additional protocols, which the courts have found actually become part of customary international law. And then there's this larger body of sort of outrages that include crimes against humanity and potentially other war crimes like the recruitment of child soldiers that come to us through custom. For an American, this is a difficult concept because in America, at one point I think we had common law crimes, but generally in the last 100 years we've adopted the idea that there has to be a very specific statute passed by the legislature, by Congress, before the crime is committed. And here we have courts, to the common observer, it looks like we're defining the law after the crime is committed. So how could the person regulate his conduct in advance? Yeah, and I think what that necessarily involves, one is, of course, a tribunal being established that clearly says that you have jurisdiction over these matters, but it still remains for the judges to determine whether at the time the crime was committed, it clearly violated international custom. That's what happened in our case. I mean, by surveying the world, by looking at international treaties and conventions and the developments that were particularly occurring in the 1990s, the judges came to the conclusion that the recruitment and use and hostilities of children under the age of 15 had been essentially universally prescribed. And as a result of that, it was possible for us to prosecute that crime because we became an authority to do it, but it was necessary to find that that was the law. That's the way we've had to develop the thing in practice. I should note that the decision of the appeals chamber wasn't unanimous. It was 4-1. Jeffrey Robertson dissented and said, no, only the forcible recruitment should be a crime, not just their use. But of course, their use included some of the most dreadful acts in the war by some young people who might have arguably voluntarily joined. So these are difficult issues sometimes to deal with, but there are situations where our judges come along and say, no, it wasn't in the custom of the world. It wasn't clear. It basically has to be very clear for us to be able to prosecute it. But that in the cases that we actually proceed with, precedents are established that I think make it much clearer in the future that individuals that use children under the age of 15 will face justice.
And Hassan, I know you wanted to make a point.
On the issue raised by Mr. King, clearly the customary international law has the advantage in the area of public international law of making the law more universal, but it becomes, its application in criminal law becomes a little bit more difficult. The criminal law requires certainty. You know, if you are going to punish people for violations of the law, there has to be a certain element of certainty in the law itself, which may not always be present in international customary law. it is true at some point the judges in their judgments will say this is the customary law. But very often before you reach that point, the issue is uncertain as to what the state of the law is. So when you are applying customary law in the international criminal system, I think you need to be very, very cautious. There may be situations where you are certain that a principle is now one of customary international law. Usually, it's very difficult to ascertain at what point it has become law, and at what point it was merely custom. So that means we have to be much more cautious in really relying on customary law in the penal area itself.
Leila, I do want to move to a new field, but go ahead.
Well, this actually, and David, perhaps you were going here. This picks up on something that David Tolbert said, which may be unfamiliar to the audience or might need a little more explication, which is what is a mode of liability? When Hague Rules were written and Geneva law was codified, there wasn't in those provisions something like, well, the accomplice as well as the accessory before the fact and the accessory after the fact. And one of the things I think I would love to hear, but maybe after, is one of the difficulties that the current prosecutors face, which wasn't so present at Nuremberg, was what do we do? Where are the limits of liability? Is it the camp guard? Is it the commandant of the camp? Is it the supervisor of the region where the commandant, I'm thinking the Blaskich case? Is it how high up the chain of command do you go? And do the soldiers down at the bottom get to say, well, look, I was just following orders or I was under duress? And at Nuremberg, there were some pretty clear rules, and there was an attempt to indict the organizations and successful indictment and conviction of some of the organizations. Everything was written down. They stuck a conspiracy charge right in the IMT statute, whereas in the modern prosecutions, there's been a lot less structured chain of command in many of these cases. They've struggled with what are the limits of accomplice liability, and yet at the same time, these are group crimes. They can't be perpetrated without a big group of people behind them because they're mass atrocities. So they have to have some theory to use in order to extend criminal responsibility pretty deep into the members of the group. And I just wanted to elucidate that for the audience and maybe throw it back to the prosecutors.
Let me just add to that, because it might give a better, more of a context for the question for our general audience, which is, are you focusing on leadership crimes? In other words, the very top leaders of these alleged crimes, as opposed to those who serve below them. And in that context, can you more effectively charge them with what we call, and what you see in the news a lot, command responsibility? Or do you actually, because in the courtroom it may be a more effective tool, to actually charge them with individual responsibility, even though they're a commander, but you go at them because of what they specifically, individually did with respect to that alleged crime. And I'd like to start with Robert Pettit, actually, because your focus in Cambodia is very much the upper tier of the former leadership. And maybe you're the best place to start this discussion as to how one launches into the accomplice liability issues that Leila was talking about.
Yeah, we are, obviously, this is something that's very relevant to us. But to a certain extent, it always is. Every time this subject comes up, I think, however, of Tadic, who was a really low-level guy, one of the first cases in ICTY, and really a seminal case in that it allowed the judges to define a whole bunch of issues that basically have been guiding all the tribunals since then. So it wasn't because Tadic was necessarily a very senior leader that his case provided that much insight. But what has been the tendency now is to really, by statute, by the people who create these tribunals, to really focus the prosecution on categories of people for various reasons: political, financial, practical. In Sierra Leone, we had those who bear the greatest responsibilities. Those were the ones we were supposed to be going after. We now, in Cambodia, we have two categories: senior leaders, which obviously seems to refer to some kind of hierarchical position, and those most responsible, which could be argued, and will probably be argued, is a very subjective criteria and really depends entirely on the evidence. And I would think also, and I think it's supported by some of the comments during the negotiations, that it's a lower threshold than those who bear the greatest responsibility. It's actually those most responsible could be quite low. But the problem in these cases is generally not to proving what happened. Proving what we usually call the crime base, proving the crimes that were committed themselves is usually not the problem. They're so massive. And there's such an incredible amount of evidence, testimonial, documentary, forensic, what have you, that it's usually not the problem. The ancillary problem is usually trying to limit the evidence to make it a manageable and understandable and compelling case. What is the problem, has been alluded, is how to link those crimes to the people who gave the orders, or the people who gave the orders to the people who gave the orders, those remotely responsible, not directly responsible, through command responsibility and through. I don't like the use of theories to say that we have to have a theory. It makes it sound like we're just seeing what if it's going to float or not. Actually, it's not a theory, it's the practice of a crime. I mean, joint criminal enterprise has been around since people have been committing crimes together. It's just a word that defines a behavior, as is any crime. Common purpose, as was applied, is the same thing. There's not that much new under the sun in terms of criminality. It's just simply how we manage to really define and ascertain and focus the prosecution and the responsibility of individuals who might have been not prosecutable if we didn't do that. If you have a massive amount of crimes and you manage to prove that people were indeed somewhere in a functioning reporting chain of command that carried with it knowledge, that carried with it authority, you usually make it undeniable, or at least not credibly deniable, that these people are responsible. But it's always, it's a recurring theme, and prosecuting the ones who gets their hands dirty is much easier than the ones who never went near the crimes.
If I may, let me ask Luis Moreno-Ocampo. Obviously, he's got numerous situations that he's investigating, and perhaps you might want to explain from your perspective how you essentially limit the scope of your investigations in terms of targets of investigation.
Okay. The idea, criminal law starts to investigate individual crimes. So normally someone kills someone and then we investigate this person. That's why the issue in a normal criminal case is have a witness who saw the crime. As Petit explained, in our cases, crime scene is easy because you have thousands of people who saw the crime or the victim. So this is the easy part. But you have thousands of victims who can explain what happened, but then also you have thousands of prisoners. And Nuremberg decided, and that was your great idea, that due obedience is not an argument. So if you receive instructions, even you receive orders, you're in a military system, you are in any case responsible and you are guilty. So criminal law has two problems. First, is a design to deal with individual cases, and we're dealing with massive crimes. And second, according with criminal law, all of them, all the Nazis, probably could be guilty. In my cases, I present the case against few persons, but I have evidence against hundreds of persons. And for me, that's a big issue, and it's no rational criteria. And let me give you, I was prosecuted in Argentina, and I was in 1986, 87 thinking, how I can find the criterion to draw a line. And I met with Benjamin Ferencz, with the other prosecutor from Nuremberg. And this was 88 in New York. I would say, oh, Mr. Ferencz, I'm delighted to meet with you because I'm looking for a rationale, how you can select people. For instance, in Nuremberg, what you did? Oh, we select 22. But you have evidence for more people, of course. Nazi were very well organized. They have documents against hundreds, thousands of people. So you can prosecute thousands, but you choose 22. And then I say, okay, that is the answer I need. Why? Why you choose 22? How you limit? Why you choose 22? And Benjamin Ferex told me, okay, the courtroom had 22 chairs. Okay? So, this is one of my lessons from my Nuremberg colleagues.
Very deep.
There is no rational. But I know at the same time, as soon as you start the case, I remember in my training, I invite the lady from Cambodia. And she make a speech saying, in Cambodia, her sister were killed. She was killed by a bodyguard who said, did you eat rice today? And the sister said, no. Then the guy took a knife and opened the stomach of this woman and showed, you did it. So, can I explain to this lady, okay, I cannot investigate this guy. It's impossible. As soon as you have this fact, how you can say no? So that's why for me from the beginning, because my lesson from Nuremberg was from the beginning be clear. I have limits, I will prosecute just those who bear the greater responsibility. That's it. Why? Because in my policy decision, that's it. There is no other, it's a pragmatic approach, nothing else. And so, the second point I like to mention on the theory of liability, I believe one important issue of criminal law is to prove individual responsibility. And I think that's something we cannot forget. We cannot present cases in which we are not proving this individual responsibility. It's a famous case in the Tokyo Tribunal, General Yamashita, who was convicted, and he proved what for him was impossible to control his troops, and was convicted. And the other day, I had a Japanese young lady who's competing for one of the positions in my office, asked her, why you are interested in this office? And she told me, look, I'm Japanese. We don't like the Tokyo tribunals. And she mentioned Yamashita. This was not a law. At the same time, in Japan, all politicians are talking about all this is not true, the worst crime was Nagasaki and Hiroshima, all the Chinese problems are not serious. So, in my country, we have these two problems. And that's why I like to be here, because it's a permanent court, impartial, independent. So, I think as the prosecutors, we cannot go beyond our evidence. That is for me critically important. Whatever political reason, is a bad guy, whatever, we cannot go beyond the evidence. And that's why I have to be very strict in proving individual responsibility. That's why command and control, you will not see a case of command and control in my court in my tenure.
I guess Hassan and David, and I look to Gregory, or I don't know, where's Gregory? I don't know my timing here. Do we want a 15-minute break, 11:15 to 11:30?